Uh, Good afternoon. This is the meeting of the licensing subcommittee of the California Paraprofessional Program Working Group. I'd like to go ahead and take roll. Brynelson?
Here.
Hamilton?
Present.
Judge Harper?
Here.
Torres Ambriz? I haven't seen Claudia, but maybe she'll join us in a little while. And if there are a few members of the public in attendance, but I'm going to go ahead right now, out of respect for the limited time of our guest, start with Tara Clark, who is with our Office of Admissions, to address the issue of the moral character evaluations. This came up at the meeting of the full working group in December. There was a discussion about whether barring from eligibility people who were denied admission in any state due to moral character evaluations would be appropriate. There was so that was one position that was voiced, and there were other people who expressed concern that some states have different requirements that would not bar people from admission in California. We have our moral character expert with us, Tara Clark from our Office of Admissions. So Tara, if you can just really briefly, if you have some examples of types of exclusions in other states that wouldn't apply in California, and then maybe we can just open it up to questions from members of the working group.
Of course. So good morning, everybody. Thank you for having me here today. And I do apologize. I did have limited time to prepare, so I have some general information for you. But the first things that come to mind, the differences between California and some of the other jurisdictions. One is a felony conviction. And so California, we don't have anything that prohibits an applicant from applying for or obtaining a positive moral character determination. If somebody does have significant misconduct in their background, then we would look to their rehabilitation, their candor, everything they've done since then. So there's nothing particular that precludes someone from obtaining a positive moral character determination. The one thing is that an attorney who's suspended for disciplinary reasons or disbarred or resigned with disciplinary charges pending or otherwise not in good standing in another jurisdiction, they're not even able to submit a moral character application for us. So a couple of the states, and this is according to the NCBE's Comprehensive Guide to Bar Admission Requirements for 2020, 3 states that do bar admission for felony convictions are Kansas, Mississippi, and Texas. They all do have some small caveats to them. For example, in Mississippi, it's a felony except for manslaughter or a violation of the Internal Revenue Code. But then there are also several other states that have felony, I'll say, carve-outs. For example, in Oregon, they're not eligible to obtain a positive moral character determination if they've been convicted of a crime of which would have led to disbarment if they were a licensed attorney in Oregon at the time. And in Florida and Georgia, they would need to have the restoration of civil rights, or Georgia also a pardon. So that is one that definitely sticks out in our mind. And so the moral character process in California, we just finished with our working group. Oh gosh, it was last year now at this point. And so we updated all of our materials online. And so one thing we try to take into consideration is rehabilitation. So that would be my first hesitation to barring anybody to participate in this program if they did receive a denial elsewhere. The second one is how mental health is considered. So I looked back, there was a survey from 2018 from some of the other jurisdictions, and the majority of them at that time still had questions related to mental health. So in California, it's not character and fitness, it's just moral character. And so for us, any mental health specific questions have been eliminated. We do ask 2 questions that are kind of similar, but it's really, is there anything currently that would impact your ability to practice law in an ethical manner? Or is there currently a chemical dependency issue that would currently interfere with your ability to practice law? So most of the other states, as I said, have more of a mental health component, whereas we don't. And in addition, Senate Bill 544, which went into effect in January of last year, modified Business and Professions Code 6060. So previously, we would only request medical records related to mental health if there was some underlying conduct we're trying to get to. But now with the change, so we actually cannot seek to review, request any medical records related to mental health. An applicant can, however, provide them to us to demonstrate either a mitigating factor or rehabilitation. So those are the 2 things that stick out in my mind. And then Linda didn't specifically mention this, but she did send me over the recommendations that the group had. And one of the things mentioned was a denied admission to the State Bar of California due to moral character or background check. The only thing I would suggest possibly is maybe considering that in California, if you are denied a positive moral character determination, it's not a bar for life. It's for a specific period of time. A typical denial is 2 years. Sometimes it's shortened to 1 year if they have some rehabilitation, but maybe not quite what they're needed. So there's nothing that would bar them specifically. So I think if possibly just fleshing that out a little bit to say if they've then obtained a positive moral character determination afterwards, they would be allowed to participate in the program. But that was the brief overview. So if there's any questions.
Can I ask a question? The group doesn't mind. Hey, Tara, thanks for doing this. What does the State Bar of California do? Say somebody is applying from Oregon or Georgia or one of these other states. When they apply, they do have to disclose that they were denied. Do they have to disclose that as part of their moral character application to the State Bar of California, right?
So that's correct. And it would automatically then come to an investigator. And so we would ask for any documents, if there was either a recording or a transcript from a hearing. And typically those would come to an informal conference. I can't think of any specific examples where they would have just been cleared by the line staff. So it is something that does get reviewed in depth if there is a denial in another jurisdiction.
Okay. So that's a process this group could consider replicating for the paraprofessional program. Not an absolute exclusion based on what another state had done, but taking it through a similar process where it's going to get vetted and perhaps go to the informal conference. Okay. Thanks.
Where is this procedure available? What am I going to Google to find the actual specific provisions for the State Bar to deal with the moral character application for someone who has been disqualified or not met the moral character requirements in another state?
So one of the products of the Moral Character Working Group are the Moral Character Guidelines. So if you go to the State Bar's website to admissions and then moral character, so that whole section has been revamped, but specifically the guidelines, it's not prescriptive, but it does speak how we generally deal with those types of issues and ones that we see frequently, and a denial in another jurisdiction is there. It does indicate that. So the three categories that we broke it into for additional inquiry seldom needed, meaning, you might have one DUI a long time ago, you provided us with the narrative, all of the documentation. It's, as long as we have everything we need up front, it's very unlikely that we might need more information or that you'd be invited to an informal conference. The second tier then is additional inquiry may be needed. And for somebody who is denied in another jurisdiction, we don't have anything in the seldom needed column because we're always going to ask for the additional documentation and, as I said, the recordings. And then the informal conference may be needed. So those were the three tiers that we broke it down into.
Okay, so I'm on the State Bar website. I'm on the admissions page.
So if you click moral character then.
So there we go, moral character.
And then on the left-hand side, so you have the different sections, but the one I was referring to specifically is the one at the bottom called the guidelines. And then if you are interested as well, the information I was discussing with the felonies, so the comprehensive guide to the bar admissions requirements, it's from the NCBE, the National Conference of Bar Examiners. That's available online as well. And I can email Linda the link if you'd like to see that.
If I could just add, Tara, in terms of the process for appealing, if that's what you're referring to, Stephen, appealing an adverse determination, I think, Tara, those are set forth in the State Bar rules around in Chapter 4 rules around 4.45 through 4.50, if I remember correctly. And then you have the opportunity to, a final determination is made by, if you go through the review process, by State Bar Court, and then they have an opportunity to seek review, discretionary review by the Supreme Court pursuant to Rule of Court, Rule 9.13.
Yes, I apologize if I misunderstood the question. So Greg's correct. And so if staff does deny somebody a positive moral character determination, they do also have the option to appeal to the Committee of Bar Examiners for administrative review. And so those are spelled out in the rules, and it's also briefly discussed under the further investigation and formal conferences section on the website.
And I just sent you all a link to the guidelines. Anything else for Tara?
I said that's very helpful. Thank you very much, Tara.
Thanks, Tara.
Yes, and thanks for being available on such short notice. I appreciate it.
Of course,
Thanks,
thank you so
Tara.
much. And I apologize. It's just we're preparing for the release of results on Friday. So
And we appreciate that as well.
Right.
Thank you.
Bye.
Bye.
thank you so much.
So before we move on, I do want to call for public comment. We have a number of people in attendance. If anyone is interested in making a public comment, please use the hand raise function in the Zoom meeting. Give it a minute. Doesn't look like anyone is indicating an interest in public comment. So let me go ahead and share again this. Oh, here we are. So after the meeting, besides this issue, the other issue that came up at the, and I'm trying to get to my controls, at the working group meeting in December, there were two issues that I took note of, but if anyone else on the subcommittee catches anything I missed. So one of them had to do with incorporating the trauma-informed representation into the educational requirements, as well as into the experiential training. So you can see I've added that to both of these recommendations. So there was this trauma-informed training, as well as the issue of the moral character evaluation. So maybe we'll want to, maybe since we just heard from Tara, we should talk about this. If we want to revise the recommendation about the moral character recommendations.
So I think we got the answers. The issue was we wanted to give an applicant the ability to address a negative finding by another state based on maybe a rule we would not adopt in California. And it seems like we could just parrot the language from Rule of Court 9.13D that pertains to review of other decisions by the state bar that an applicant wants to appeal. And then E sets out the contents of their petition and F sends out the service requirements. Seems like we could just cut and paste those into being the appeal process if we deny someone a paraprofessional license based on an adverse finding by another state. Or actually even our state too.
Yeah, I think there's kind of two issues. One is the appeals process for an adverse finding, irrespective of the bases, I think. And then the other is there going to be any kind of automatic disqualifier based on an adverse finding in another jurisdiction? And I think that was the initial kind of position. And now maybe there's some interest in changing that and handling it the way it is done on the attorney side here, which it sounds like there's a requirement to disclose it as part of the application process. And then internally, there's some kind of escalation of those types of applications. They're handled a little bit differently, not just at a regular old staff level. So maybe there'd be a recommendation that they get handled the same way for a paraprofessional with an adverse determination from another state. And then there is also the establishment of an appeals process for any adverse finding. Does that make sense?
Yes.
So this is Julia. So I'm I'm comfortable, Stephen, with recommending that we follow the same process that the state bar follows.
I am too. So I think that deals with the second issue of what can an applicant do if their application has been denied, regardless of whether it's because of some activity in another state or whether it's because of some activity in the state of California.
Mhm.
And so I think for part two of it, we can just literally cut and paste Rule of Court 9.13 D, E, and F and amend them to fit the paraprofessional.
Yeah, in our list, we can just say with our list of recommendations that we want to follow the rules consistent with the rules and processes established by the state bar for attorneys.
Mhm.
I'm not sure though that you need to, I think Rule 9.13 will do its work all by itself. Because that is the avenue to Supreme Court review of any body of the state bar, which the paraprofessional board, or in this case, whichever entity within the state bar that we envision would make a final determination on that level. That would still fall within, I think, the scope of 9.13. And so I don't think you need to do anything in terms of that portion of the review. I think what we would need to do is scope out the type of review and the process and procedures within the state bar rules that lead to that point, if that makes sense.
Mhm.
I have a confused look on my face.
Well, so 9.13 is really our rules, the Supreme Court's rules for when we will allow either for that particular rule, and there's other rules that pertain to the Office of Chief Trial Counsel, or if they want to seek review from the Supreme Court, if there's an adverse state bar court ruling that OCTC is not happy with, or the admissions folks are not happy with, they can follow other rules to seek Supreme Court review. 9.13 is provides a procedure for individuals, so licensees or other individuals who receive an adverse determination by any entity within the state bar. So it could be the Board of Trustees or any entity, any sub-entity within the state bar that the Board of Trustees delegates decision-making authority to. And that lower level process is really set forth in the state bar rules. But once they have a final determination by whatever that sub-entity is or the Board of Trustees, then you refer to Rule 9.13 to seek Supreme Court review. Does that make sense, Stephen?
Gotcha. 9.13 is kind of like the second step, because there's an initial step that's in the state bar rules that
It's actually the final step.
okay.
Yeah.
Where would we find the first step?
Those are in the state bar rules that I was referring to. I think it's in the chapter 4 rules. I'll look for a link and try to send you, but they're on the state bar website, bit buried, I must say.
Yeah, I think you said up through 4.50.
Yes. But if you're on the state bar website and the homepage, you click on attorneys, and then there's a number of menu items at the top, conduct and discipline. And then you look to the left, there's a link that says rules. And you'll see under rules, it says rules of the state bar, and then rules of professional conduct, and then selected legal authority. If you click on rules of the state bar, you'll see, they're the Title 4 rules. I was saying chapter 4, Title 4 rules, admission and educational standards. If you click on that HTML link, the Division 1 rules, admission to the practice of law. You click on that PDF and you see the chapter, Title 4, Division 1 rules. And I think they begin, the whole moral character process begins around 4.45, if memory serves. Let's see.
Okay, 4.5 is submission.
It begins at 4.40, moral character determination under chapter 4. That's why I kept thinking chapter 4. It's Chapter 4 under Title 4. And so this is the process for moral character determinations for attorneys applying for admission to the state bar. What you would probably want to do is have something similar to this for the paraprofessionals. It may be very similar to this, actually.
Gotcha. 4.40.
So if you see the 4.40 gives you the basic definitions of moral character, and then what's required of the application. Duty to update is 4.42. When you abandon an application. So this type of process, we would need to replicate that in some way and adapt it if we want to adapt it. If we have a different sub-entity making these determinations within, it's at a staff level initially, and I think that would probably remain the same.
That makes sense to me. Right.
Yeah, so I think to give something of substance to the working group as a whole, we could, I keep using the phrase cut and paste, but basically it would be take everything from 4.40 through 4.52, and then also incorporate 9.13 D through F for that final appeal process if someone has to take it to the state bar. Does that sound right to you, Gregory?
Yeah, that sounds right. And one thing I'll mention about state bar rules, those just need to be approved by these sets of rules, unless there's either a rule of court or a statute that requires Supreme Court approval. Normally, state bar rules only require the approval of the Board of Trustees. I think this set of rules falls within that category. So the state bar would have the authority to promulgate these rules on their own.
And
Once they've been vested with the authority either by the court or the legislature.
And I think your right to practice that's been either prevented or suspended by another state, that's part of the moral character application itself, correct? That's how someone would notify the state bar that they're right.
Yeah.
And so it doesn't talk specifically within those rules as to other states. Let's see if I can find the word suspended in there.
I think you're going to find that in the guidelines that Tara referenced.
The guidelines that they referred to earlier, I think we'll probably have that.
Okay.
Yeah. But I think if the group is wanting to basically say that the intent is to replicate the moral character process that's in place for attorneys, then I
Yes.
think we can write that up. And then however that needs to be effectuated, then that will flow from there.
So
Yeah,
Linda has the work to do.
Yeah. Well, the guidelines that Tara directed us to is 33 pages long.
Yeah.
Yeah.
Okay.
And some states, I think like maybe Arizona, where they've implemented the paraprofessional program, or they're about to, I believe it's Arizona, maybe Greg, you remember, they simply just added triple LT to all of their existing rules for attorneys. So that was all they did. They didn't create like a whole new set of rules, new guidelines. So that, that'll be an option.
Yeah, Arizona really took it was easy probably for the court to do this by a single order, but it's very difficult to try to then cross match the order with the existing rules. And I think they're working right now on providing a revised set of rules so that it's clear which rules apply, which ones don't. So it may be easier for folks if we approve a set of rules and not force them to do that kind of cross-referencing if we want to ensure compliance.
Does anybody know, so that when I read those moral character determination guidelines, it makes it user-friendly. It says they seldom need additional information when it may be needed, or a conference may be needed. But all of these determination guidelines are based specifically on state bar rules. What's the source of the authority for this so that we could look at that too? Does that make sense?
We should look into that. What I would say is probably a lot of it's based on case law. We haven't, I mean, I think the last moral character case that the court took was the Stephen Glass case, but for years we really we developed that case law, and I think they're reflected up in the guidelines, and there've been some changes by rule as well. So tracing the original sources may take a little bit of work, but it's doable, certainly doable.
And some of it, I think, was an intent to codify practice. So you may not find a sort of a authoritative source for every single aspect of those guidelines, because there was a lot of concern about this sort of, not a shadow process, but there just wasn't a lot of transparency about the process that the State Bar was undertaking. And so the guidelines were also an attempt to codify that.
Oh yeah, I agree. In terms of the process, I think that's true.
Yeah. So it sounds like Stephen, you would like to see whatever authorities there are for the guidelines.
Not necessarily. Seeing as how Linda's got basically 2 jobs right now dealing with giving everybody their source materials for all the meetings that are occurring, that may be too extensive a part. What I'm trying to get to is, are we just going to use the moral character determination guidelines and which would require very minimal change? I do want to make sure that they talk about other states, because it talks about suspension from practice.
Well, can't we, I'm certain if we look at the guidelines, they can't, I mean, we can have a list in mind for our next executive summary, but perhaps for our next meeting, we can simply look at the body of law from the applicable rules of court and the applicable guidelines, which are like, I envision are similar to administrative law regulations, right? Because they tend to govern procedurally how that process will be followed. So I think if we can put that together, I don't know that we need to know why California State Bar uses these guidelines, as long as we find them acceptable to be used for applicants of this program.
And Stephen, I think the relevant other jurisdiction language, it's page 14 of guideline, denial of admission to the practice of law.
Another, yeah, okay.
Yeah, and then 15 is also good because it's denial of, another license.
I think I need to look at the actual application. I think that's what I'm missing.
The application for?
Moral character application.
And where could we find that?
It is also, it's all through an online portal now. There used to be or paper application. Let's see. I think we're going to have to get it to you because we don't, unless Linda has an account. I don't have an account on here.
I can track it down and if it's not something that I can get through an online account, I can just ask admissions. I'm sure they can provide a copy of it, of the application. Talk to Tara about that.
Okay. But it sounds like there's general consensus that we're going to apply the attorney process.
Yeah.
Yes.
Okay.
And so on, I think the only other outstanding issue was this, the idea of incorporating the trauma-informed training into the baseline requirements, the global requirements, as opposed to just having it for family law. That was something that was discussed. And as you can see on this page, I added it to the educational requirements. And I also added language to the experiential training. I just want to get your input on that and see if you agree with the way that it's provided in these two places. Let me know if you want me to go back to the previous.
Yeah, go back to the other side. To have it be a 3-unit course to me makes it a little overwhelming. I can understand it for family law. I mean, it's like we're going to really have to also establish the difference between evidence, court procedure, and advocacy. I mean, we may have to revisit that at one point, because you may want to allow folks to test out of evidence, because it is taught as an elective in many paralegal programs, and it's taught in law school. So, I mean, I think we're trying to make sure we get folks through this as long as they can pass certain competencies. But I reflected on this trauma-informed representation. I have no problem if Stephen thinks 3 units is appropriate for the family law folks, but I think to require it for every subject matter, I'm hesitant.
I agree. It really was. I don't know who was advocating to include it in all areas of representation.
I think it was Judge Yu.
Okay.
And we discussed the fact that
It's a
it's
great
not
idea.
required of attorneys. And so I'm a little hesitant to say that it should be 3 units. That seems very substantial to this, and also require it in the experiential. I would like to hear it included in experiential, or, I mean, Stephen, you speak to it as if we were speaking of family law. What do you think in terms of units and or in your training for the experiential requirement?
I think that for the education, that highlighted 3 units trauma-informed representation should be a requirement in family law for the educational component. And that I think that on the experiential, I think that's going to be covered through the experiential training if we're going to require that some of the practical training for family law attorneys include work with, for example, a domestic violence clinic.
I don't see how we can require it if the state bar doesn't require it. I mean, we got to remember, we want as many folks willing to supervise these applicants. And if you make it too onerous, I mean, it's already that way sometimes with paralegal internships. They don't want them. They've got to spend too much time with them, looking at them, supervising them. So, I mean, I think we should just assume that in family law that they attest in their declaration, that it can just become part of their declaration that they did include some experiential training in the area of trauma-informed representation.
I would agree with that. I would say if we are going to include it in experiential, it should only be in family law, but even then you're going to pick up on that. On an experiential level, it's just going to be when they're doing their practical training or their internship or whatever it is, making sure they know when to refer a client, particularly in family law, to a mental health professional.
And you think that really requires 3 units of a course?
I think that the answer is yes. For trauma,
I think maybe if we could talk to someone who teaches this kind of thing, because to me, I mean, sometimes, I mean, that's a lot of hours in the educational arena. And I'm just not sure that it requires 3 units.
This is Mike. I agree, Julia. I think it's great to require it, but I don't know. It'd be nice to talk to somebody to see how much time do we really need to 3 units is a lot of units in that area. So it'd be nice to know, what does that mean?
What's
Yeah.
our conversion rate of units to total hours spent?
I think it's 15 hours per unit.
Yeah,
Judge
so that's
Hooper-
like 45 hours in class. And,
I'm okay dropping it to 1 unit.
okay,
Can
you
I,
know, and then I think later we're going to have to talk more specifically about our recommendations for evidence, just because after reflection and thinking about what is being taught in paralegal school and in law school, I'm sure that some of the same instructors would want an opportunity to teach this evidence, but it can't just be duplicative. And so I have to find a way to articulate, you know, what the student learning outcomes would be that would be different for this training versus the training they're receiving now. So I may have to spend some time, or I could maybe bring some of the student learning outcomes for that course that we teach. But you know, I think we may want to consider some additional things. So Stephen, are we going to say right now that the educational requirements that we're looking at right now, if we change the 3 to 1 unit, and then in perhaps, Linda, in the second slide that you were showing us, you can maybe state that it's going to include some area of trauma-informed representation and possibly to be included in a statement of the attorney's declaration.
Yeah. can do
And
that.
then I don't think we should say at this point that we are going to require it for every subject matter. I think we've got to wait until those shake out a little more specifically.
Yeah, probably anything that involve like family law, guardianships, conservatorships, elder abuse actions.
Sure, I agree. But when it comes to, I don't know about the, you know, unlawful detainer stuff.
I don't, it's not required for attorneys. I think unlawful detainer, the collateral criminal, they don't need it. I think that section can be moved. That's highlighted on the primary slide right now, Linda. So that could go to being part of the subject matter units based on practice area. So change it to 1 unit trauma, and so family law would have 1 unit of trauma-informed representation. And I would say this, Julia, I do want to we've got a family law meeting I know coming up relatively soon. I do want to run this by Fariba too, because this is one of the points
Sure.
that she was pretty zealous about advocating.
Sure. I just,
Judge Harper, can I ask Judge Harper a question?
Sure.
Judge Yu, when she raised this, initially she indicated that judicial officers were now required, or were going to be required, to take some kind of course relating to trauma. Is that ringing a bell with you also?
I think that's the hope. I don't think it's a requirement yet, but I think that there's definitely a trend to training all judicial officers in this trauma informed representation. I think that the idea is to try to have some understanding of people who have faced some sort of trauma, where they're coming from, and so you can have ability to understand where they're coming from, and that's the thing. I think you can start, you know, like Stephen said, it to not have it in unlawful detainers. I think there's an argument you can have it in unlawful detainers, because a lot of times you're dealing with people who are being evicted because of trauma-related issues. So is whoever's representing them, the paraprofessional, has to have some sort of understanding of where these people are coming from and what they've gone through, so that they can more adequately, I think, represent their positions. So you
Yeah, that's why I was
can it out into all the subject areas.
collections, collateral criminal expungements, reclassifications, all
Yeah.
these folks, the wage and hour cases. You know, people are finding themselves in very challenging situations in all these case types.
Yeah, no, I agree. That's why I agree. I think the 1 unit is fine. I don't think 45 hours but I think one unit's fine, but I think one unit across the board would probably be helpful.
So
Can I speak to that? The only thing I just want, I guess we're encountering the new problem, and that is there's an area, a substantive area that more and more people are being exposed to. For example, I'm a mandatory reporter, yet I don't even get training in this either. But I have to report to my dean when I see something or learn of something that gives me the antenna up. And it is also a new avenue of education. Is there going to be a new style of educating folks, you know, who have suffered trauma? So I totally agree that it is something that should be included. I'm just thinking, from the teaching aspect, none of us are required or experts in this training. It sounds like it would be a non-legal professional who perhaps could be teaching this.
Yeah.
And I'm not, that's what I'm trying to envision it from an educator standpoint is, first of all, there's no one really to go to yet. I mean, maybe we can hear from the judges, like Judge Harper's telling us they're intending to start this training. Once we see who's lined up for them, we can get a better sense of the scope of the training and who would be performing it. I'm just having a hard time to envision how we're going to teach this. I mean, one thing is to flag cases, but the other thing I think is who would be the person that you'd hire to teach that?
Yeah. Well, I agree. And I think obviously Santa Clara County it sounds like they're already doing it there because of those resources, but I don't know of any other county that's doing that.
Interesting.
I agree. I don't know who's providing that service.
So
Well, and we aren't required to have it as lawyers. It's not part of our MCLE, and we don't, I mean, here I am an educator, and I'm even not required that I know of to take a specific course in that. So
UCLA has a 2-unit course that started Monday on re-envisioning the lawyer's role, trauma-informed lawyering, and restorative transformative justice. That to me, when we get to the nuts and bolts of it, that's the first person I'm going to call. It's 2 professors teaching it. Claudia Pena and Alicia Verani. That was the first thing that came up on my search, looking for law school courses on trauma-informed lawyering. So my guess is we're going to have a resource we can go to, Julia, to develop this. And I think Judge Harper just won me over. It's that small county thing probably going on.
Yeah. A lot of trauma up here.
I think that maybe making it required for everybody, even if it's not required of attorneys. So what if we have a higher standard in some areas than the state bar does? Maybe it's just a question, or for attorneys, maybe it's just a question of it's okay to take the lead on an issue like this, because that may cause the state bar to now say, you now have to have every 3 years, 1 CLE hour on trauma-informed lawyering.
Yeah, I agree.
Have you, Judge Harper, did you do the family law primary assignment training?
I did, yeah.
How long ago did you do it?
Oh boy.
Long time ago.
6 years ago, yeah.
I think that they've incorporated that Seizures now included that as part of the family law primary assignment.
Yeah, when I did it, it was not. But
yeah.
I did some dependency training recently, and they're starting to do it in dependency as well.
Yeah. So I think, Julie, so I'm going to respectfully retract my position. It should be family law only. Do it as 1 unit, because now it's not that onerous a requirement on everybody. And you just do it as 1 unit, trauma-informed representation.
well, that sounds fine with me. We can do it that way. I mean, I'm sure we'll get some more discussion from the rest of the group, but I think if we could have some more information about what that would look like, that would help me speak, as we present next time to the full group on the issue, Stephen, or maybe we can agree that you're going to speak to this, but we will have you know, maybe we can obtain some money from the information from the UCLA folks or whomever who teaches it, so we can get an idea of what we're envisioning this class to consist of.
Yeah, we can try to reach out to them and see if we can have someone speak to you guys.
That'd be fantastic. Thank
Yeah,
you, Leah.
really interesting. I
Yeah.
think I love what you had to say, Stephen, because I was just really shocked when I found out that the MCAT, you know, a whole section of the MCAT now is on trauma-informed practice, how you work with your clients in a culturally responsive manner. So I kind of think the legal profession is behind, and it's okay for you all to take the lead here.
Yeah, and it's not like this isn't a situation where we're having this one, as long as we can find educators to create the program. I think these two professors at UCLA would be excellent potential resources. Let me do this. I'm gonna chat. Is the chat window open?
Oh, no, we've disabled that.
Oh, that's right. I'm gonna email you, Linda, the web page that
Okay,
had that had this course on it, and let me just save it in there. What you have to do is you have to scroll down to the bottom because it says there's a second faculty instructor, but you don't see her information until the end because
okay.
the course description's got them both listed at the end. But I'll send that to you at some point when I have a break, like
Thank
the
you.
next hour. Okay. Do you want to come back and talk about evidence, Julia?
Yeah, I just I wanted to I want to bring, or maybe I don't know if you have access to this, Linda, so maybe what I'll do is send it to you and we can look at the kinds of things that are supposed to be being taught in our evidence class. I mean, I took evidence in law school as well, but I think I wanted to talk about whether or not it made sense to take evidence and put it in with court procedure, or if they're really two separate classes that we're talking about. And I was looking back at Arizona's list, and I think they combined them, which is, but I would want to look back at that again.
I think when I had brought up evidence as a separate unit before in the initial discussions, I was looking at a practical training. How do you get the records and documents that people need, not just for hearings and trials, but doing subpoenas, notices to consumer, a really practical base, and that's being taught. You teach that, right? For the
I
paralegals?
teach civil procedure and litigation. I mean, I don't know that this is the problem, to not be the only person who teaches it. I know it's taught a variety of ways, even at one learning institution, but I have a really good sense of what I like them to know how to do. And that's why I'm trying to get in my head, how are we going to differentiate these things from what folks possibly could have already learned in school as a paralegal, or are we just going to let them try and test out of everything except for advocacy? Because, it would be helpful if I also showed you that information so you could see, for example, in civil procedures and litigation, they're supposed to spend quite a bit of time on discovery in California, not just federal. It's supposed to be, and I know that some do that more than others. I really focus on California. And then I also teach another class that is specific to, like request for production and introduction into metadata mining. So I think it's helpful to have additional discussion about what we envision for these classes. If I maybe can educate you a little bit more on what, or whoever you want to read, if you want to read some of the student learning outcomes of our classes to get a sense of what's already being taught, hopefully, at these ABA approved programs at least. And if some of what you're considering is already being taught, maybe give them a chance to at least test out of some of it.
I think that this information you're talking about, I think is in information that I already provided. I sent around, it was a big packet, it was over 100 pages of the course curriculum, and it was course descriptions. And maybe Judge Harper, you didn't see that because it was before you joined the working group, but there were course descriptions. I went to a whole bunch of different programs and looked for course descriptions on what's taught.
Yeah, I think that you did
paralegal
provide,
programs.
yeah, you did provide our catalog description, but this is an internal document, and
Oh,
I'm
I
not
see.
sure.
Do you, are you thinking, Julia, that, for example, if somebody took evidence, let's just say evidence, at in law school with a passing grade, or they took it in an ABA certified paralegal program, the passing grade, then they would be eligible to test out of that requirement. That there would be like a test that one could take to test out of the unit requirement. Is that what you're thinking?
Well, I'm thinking that, but I'm also thinking in what way, you know, so one, Stephen, now I have a little more clarity, is when you're talking about evidence, you're not talking about how to get evidence into the record. You're talking more about discovery.
I'm talking both. It's obtaining the evidence and then how to have the evidence admitted during a proceeding.
So what so what I would say, the initial thing that you're referring to in my mind as a teacher is you want them to make sure they know about discovery and how to get things before hearing or trial.
The discovery, but also if somebody went to an ABA law school, and even in the California law schools, they're dealing with the federal rules of evidence, and there are significant differences between the California Evidence Code and the FRE. There's a lot of mirroring, but we've got a difference. So I just pulled out my Jefferson's evidence bench book. I'm kind of looking at, you know, even.
Well, I guess that's what my question is I'm unclear. We have a separate class for evidence, and that goes over all the hearsay exceptions, all that kind of stuff. That's taught by a criminal trial lawyer. And I guess what I'm trying to envision is, what do you see being in evidence? What do you see being taught in court procedure? And I get a sense of court advocacy, that I have a sense of how it is to, you know, do moot court or whatever it is we're going to say they can do once they're in a courtroom, once the whole group decides on what that is. But I think we've got to I would like a better handle on, what do you envision being taught in evidence? What do you envision being taught in court procedure? Because for me, evidence is not discovery. Evidence goes with court procedure. If you're also talking about discovery, then that's pre-hearing, pre-trial collection of evidence. But I talk about that specifically under discovery. So, you know, I think if for the discovery segment, if folks can test out of the discovery part, if they got enough of it, the actual, you know, because I go through, and not every professor does, so I'm not saying that many people could test out of it, but I would like to believe that my students know the difference of when they have to just do a notice of depo versus a deposition subpoena, and they know how it has to be served, and they know when they need a consumer notice. Those kind of things.
Julia, can I ask you, when you're teaching discovery, do you teach also evidentiary objections, responding to discovery, or?
Some, yes. I mean, we go over what attorney work product is, attorney-client privilege, mostly the privileges. But in evidence is when I believe that, which is an elective, I think is where they go over the objections.
I think we previously agreed the professional responsibility could be tested out of, true?
True.
Okay. And I understand the issue with the labeling, but with us reducing the trauma-informed representation down to one unit, even if we had a evidence unit that was repetitive of some aspects of a law school evidence course and other repetitive of aspects of a paralegal course, I'm still not offended by the rules of evidence, hearsay, and admissibility of evidence being dealt with in a course. I understand what you're saying about discovery, but again, we're not going to require discovery education for someone that's doing the collateral criminal only, right?
Well, that's why I was saying,
Yeah.
if it's going to be evidence, I mean, that's why I'm saying, if it's collateral criminal, why are they doing 3 units of evidence anyway?
Right.
So I guess what I'm saying is, we may have to reflect once we get on these subject matters. But what I was thinking is, if you want to call it discovery and evidence, I mean, I guess I'm having a hard time distinguishing between evidence and court procedure. And sometimes I think I'm having a confusion between court procedure and court advocacy. So I'm trying to get it more straight in my head.
I'm going to pull up the
Are
walk.
you thinking, Julia, it would be court procedure and evidence combined for 3 units? Or are you thinking it's a combined? Because I hear you focusing on the content and trying to figure out like what would be different content-wise. Do you think they can both be covered in 3 units, both presuming there is something different about court procedure and evidence, or that's what you're trying to figure out?
Well, that's what I'm trying to figure out. Now, I understand that things are different perhaps for family law, because you do really have to know family law specifically about how you're going to help a self-represented person in a court advocacy situation. But I'm thinking, if we're going to say that 3 units of evidence, but it's going to be civil discovery and civil evidence. I mean, I guess that's the other question too. Are we focusing on civil law? Are we focusing on criminal law? I think the labels are important just in order to have an idea of what I'm considering in terms of substantive legal classes that are different from classes elsewhere.
Where does local rules, like, does this contemplate training people on local rules, and not specific local rules, because we got 58 court systems, but the idea that there are local rules, these are things you never hear about in law school.
And
Like that
I teach that.
At the local rules, and you have to know how
Yeah.
to do things. And I'm also thinking about strategy, like thinking about family law, dealing with child custody, mediation, preparing your clients. Like, is there any aspect of this training that we are thinking is strategic in nature?
So what I would say is this, and again, I'm going to say I teach the way I used to supervise and train paralegals. And I know that there's a lot of people who probably are easier than me. But I literally, in legal writing, force them to go look at the local rules about what has to be in your notice of motion and why, what is a tentative ruling, why you have to give them the deadline, what happens if nobody calls for oral argument. I go through that whole thing, and I do that in legal writing. Then there's other things that I have them go for: motions for summary judgment, to go to the court rules to see what a separate statement is supposed to consist of. And I do that for my motion to compel further discovery response. So I really take them through all the different areas they're supposed to be aware of to look at. Unfortunately, there are a lot of professors that don't. So I'm going to say, just because I do that, I'm not confident that all of them are getting that. And so I can see if that's what we're talking about in addition, how now I'm seeing discovery evidence, or are we going to keep court procedure, also additional local rules, California court rules of court. I mean, if this is helpful to me to continue to envision what these units represent.
What if the 3 units evidence was relabeled discovery and pretrial and obtaining pretrial evidence?
I guess the only thing is evidence isn't evidence until it's moved into the record. That's the way I look at it. I mean,
Well, I think that combining the evidence and the court procedure, it's one thing to learn the rules of evidence, but it's another thing to actually do it in practice. And even attorneys who've been practicing for 20 years don't even know really how to practice. So I think that idea of combining those makes sense. And then having a pretrial discovery is really a kind of in my mind, a different area. Evidence and presenting evidence in court, knowing the rules of evidence, that to me seems like one area that could be combined.
yeah, so I mean, maybe we could do evidence, objections, and court procedure, and like combine that, or put it with even court advocacy. I think the thing is, that's what I'm trying to envision, is because what I'm concerned about is I don't want paralegal instructors to just show up. Oh, well, I teach evidence in a paralegal school. I'll go teach evidence over there and just teach them the same stuff I teach these other students. It's got to be something enhanced. It's got to be more.
Isn't there going to be, once our recommendations go to the state bar, there's going to be some aspects of our recommendations that are not going to be fully fleshed out or described, right? There's going to be a process after our recommendations. Isn't that?
Yes, I think that's been being contemplated, that we would then work with to develop the specific course curriculum.
Well, I guess I just wanted to keep it open that maybe these labels could become confusing as to what is contemplated in each instance. And so what I was hoping is that I can make it clear in my mind what additional things are being taught in these courses that are not available to these paralegal students when they come in. And if parts of it are there any parts of it we can get them to test out of, like we said, that if the law students can test out of the professional responsibility portion, great. They should be able to do that because they probably took it in law school. So I want to give some chances if there's another area that we can give a chance to. Otherwise, I just really have to have it in my mind that it's going to be an education that's different and superior to what is being learned in paralegal school.
I think you're judging paralegal school by what you do, and you're the high water mark. I mean, that's evident from the conversations that we've had. And I don't know, I would suspect that more paralegal programs are teaching at a markedly lower level than what you teach at. And that's based on hiring people for 25 years.
I'll accept that as a compliment.
It was meant to be so, but it wasn't meant to be patronizing. I think that if we eliminate or allow testing out on evidence, and people can test out a PRE, and we're not requiring court procedure for everybody because it may be overkill. Look, there's got to be some baseline requirement for the education. And right now we're down to 3, 6, 10 units, not including the PRE, which is easily obtainable in one semester. I'm concerned about cutting down, letting too much testing out occur.
Okay, so let's just work on the portions then, and because I'm kind of a linear thinker, why don't we call the first 3 unit ones talking more about, we can just call it discovery and evidence. but it's with the idea that this is pre-hearing, pre-trial. Then court procedure and court advocacy can be somewhat different. We can be talking about court procedure is going to not how to move stuff into how that move that evidence into the record, but also in terms of other court procedures. Then advocacy makes sense standing alone. I think if we call evidence, you know, pre-trial discovery and evidence helps me envision that this is what we're first getting the information, then how you would present it, and then 3, advocacy is also going to be strategizing, etc. So then that to me makes sense if we think of it in a timeline.
Agreed.
So wait,
And-
just so I have a complete understanding. So we want to have 3 units of pretrial discovery and evidence, 3
Yes.
units of court procedure and court advocacy as one class, or
No.
3 units of court procedure and 3 units of court advocacy?
Yes.
But the
Got
court
it.
procedure is going to include, it sounds
Evidence.
like evidence, moving the
Got it.
evidence
Yeah.
into the courtroom, right?
Right.
And inspections and local court
Got it.
rules, all of that.
How to do a request for judicial notice in the appropriate way and
That's a
making sure.
great class. I wish they offered that.
Yeah.
I wish they
And
offered
I'm
it in
okay-
law school.
Look, I'm okay if someone overlaps with their prior education that they have, because that's just going to make them better.
And let me ask you this though, this is then the sinker. Are we going to call it pretrial civil discovery and civil evidence?
No,
Because we're going to have only one criminal. Right now, we're only envisioning, you know, the expungements and that stuff. They're different people who teach the criminal stuff versus the civil stuff.
But I thought when we had all the discussions to develop that collateral criminal piece, we were told that's not a criminal procedure. Expungements and reclassifications, that it is more akin to a civil.
I agree with that. I think it is more of a civil.
yeah.
Yeah.
And I think that's why we left it in, because we were very concerned about anything that it had a potential punishment associated with was not going to be within the scope of the program. The other thing I'm thinking too, Julia, these are our subgroup recommendations to the committee as a whole, but ultimately there's going to be a final report prepared that is going to be more than just the slideshows. Ira's on, he's listening. We've got you. So we have 2 people that on this specific section could, with the input from other group members, in the final report, we could have specific topical areas that are identified that we don't need to get to now in
Right.
terms of making this recommendation to the group. Does that make sense?
Yeah, I would only hope that we would change evidence to say discovery and evidence before hearing or trial.
Agreed. Change it to pretrial discovery and evidence. That's what you wanted, right?
Yep.
Take out the highlighting on trauma-informed representation and change it to 1 unit.
Right.
Yep.
That's it.
Right.
And I, course at UCLA. And I just, whoops. Okay. And I just sent you the email, Linda, with the link to that course at UCLA.
Okay, so I think what we have, the next meeting is a week from today. So what I plan to do is to send to all of you the rule, both the state bar rules, the California rules of court, and the procedures for the moral character application, as well as tracking down the application itself. And I will get in contact with the UCLA and if I can find some others to get information about the trauma-informed training, and maybe we can have someone from that course come in if they're available to speak with you next week. And I will, I think I'd like to try to get working on drafting the recommendation that's going to go to the working group in February.
Mm-hmm.
Because if we get all the information we need at the meeting next Wednesday, then perhaps we don't need to have any more meetings of this subcommittee prior to the February meeting.
The other thing that we kind of were still brainstorming on, and Claudia's in here, we were talking about how else to make it incentivize attorneys?
Oh, right,
And I
that's right.
we
And I
did-
got an email from Claudia saying, apologizing for missing this meeting. Apparently she's on the road, but she said she will be able to make the next meeting. So that was the other, the last remaining. And in fact, I had a slide for that.
we had supervision credit for teaching law school classes provided on a 12-to-1 basis. If you teach a 2-unit class, you may claim 24 hours of CLE. Credit for teaching at a CLE class is provided on a 4-to-1 basis. So that has to do with the teaching, but we were talking about, I mean, I'm not sure how that matches with the supervision. So we were saying that if they provide 12 hours of supervision, that's going to entitle them to 1 unit of continuing legal education. So if you teach,
It's 12 to 1 for, it's the other way around. So if you teach a 2-unit class, you get 24 CLE
correct,
credits.
so so that means so what we're saying then, if you,
We're not saying yet. We're using those as a guideline to figure out what the credit should be.
so it should be 24 hours of supervision, 2 hours earned of CLE credit, right? So that's what we're saying. They can get, for every 12 hours they supervise or that the student is working there under quote unquote supervision, as they will declare, they're going to earn for every 12 hours 1 MCLE or CLE credit for that supervision. And I think we agreed that was a good incentive. So instead of saying if you teach a 2-unit class, maybe we could say, so if you supervise for 24 hours, you will receive 2 credits of CLE credit.
So just 12 to 1. Do you think there should be a cap on how many CLE credits you should be able to get by doing this, so that someone can't completely satisfy, other than the mandatory units, all of their CLE by doing this?
Well, if we're restricting how many students they can have at a time, we are restricting it.
I could easily do all my CLE with this.
The way I look at it is that's on you. We're going to need to incentivize these supervising attorneys. I mean, I'm telling you, it is not easy in private practice to get attorneys to do this stuff.
Well, and
So
again,
you're saying 2 units for every 24 hours of supervision?
Yes,
Okay.
and ultimately the state bar is going to have to decide if that's really appropriate.
right.
Yeah.
But we had wanted to start from some source.
I think it's fine because we don't even require that attorneys do their CLE in any area associated with where they practice.
Yeah.
I mean,
It's
there's
on you.
Apparently I'm getting my windows cleaned.
How nice. Well, so I think,
and do you think you've reached the extent of where you want to go with the incentives discussion?
no,
Okay, that's right, Julie.
how many, I guess what I'm trying to remember is where would I find how many we limited them to having on a yearly basis? Do you recall, Stephen, where did we put that, or what did we discuss about that?
I can bring up the recommendation that was presented at the
Okay,
December meeting. Hold on, let me find that. Here we are. Let me just share this. So can you see that now?
let's see, we went from 48 hours now to 1,000 hours. So that's an older one. That's not the December one, Linda?
So on the right side is the revised
Oh,
recommendation.
gotcha, gotcha. Let me move my screen so I can see requirements for supervisors. Active for at least 4 years. Okay, supervision, less than 5 applicants at 5 or less applicants at a time. Well, I guess the only other thing that needs to be added then is that, I mean, unless it's appropriate, not appropriate to put it here, is that the other thing is, i.e. for family law, they agree that they're going to provide the trauma-informed.
I have a question. If you're supervising, say, 4 applicants in the 12-to-1 ratio, are you gonna get for per applicant?
Yep,
So like you said, I think like Stephen was right. You're gonna get your CLEs taken care of very quickly.
Well,
Anyway,
if you're supervising 2 people at one time, do you get an hour for each of them, or do you get it 1 hour?
no, I think you got to give them credit for each person, each student.
is
So
the
maybe
background noise deafening right now? Should I mute myself?
No,
I
Okay.
can't hear it at all.
I don't like the idea that they're really not doing CLE then. They're teaching what they already know. But I think the greater good is to ensuring we have a sufficient pool of attorneys willing to provide the experiential hours, especially after we had this requirement much lower initially. And then Amos Hartzman suggested we increased it because of consumer protection concerns.
right. So
I'm begrudgingly okay.
And
but
just,
was it Amos that Amos wanted to have 5 applicants at a time? I thought he wanted the greater experiential hours.
No, the hours. What I'm saying is, in light of us increasing the hours, it's going to make it even more challenging to get supervising attorneys, and therefore we want to increase the incentives.
Yeah, I
So
mean, if
and
we want this
instructors who instruct for MCLEs, they are instructing in the subject area they know, and they're getting those credits as well. So it's really not much different.
yeah, I'm an instructor, and probably I like quintupled what it was required for my current reporting period, but probably half of that was from instructing.
Yeah.
Which, by the way, when I go to the state bar site to fill out my compliance card, which I have on my screen right now, it's still asking about 2018 to 2021. They didn't update the years.
We'll take that to the proper authorities.
Thank you. Since I have you here as a benefit of the time that I've been spending with the group, I do know people.
Well, we're having less of a more of a casual conversation. Can I ask, does anyone hear clicking coming off of my camera, or am I okay today, Linda?
oh, I'm not hearing that today. Yeah, I noticed that.
Nothing.
Okay, because I put it into a different USB port and I wanted to make sure that I knew if I had to get another camera or not.
No, I think that might have solved the issue.
Thank you.
Oh, wait.
Okay.
If we have a minute to go back to what you all want to see happen on the moral character piece. I know, Linda, you said we were going to send out rules and whatnot, and that's fine. But I think the direction was to try to modify the existing framework to include paraprofessionals, right? So either, I think, Greg, you're suggesting just not adding paraprofessionals to the existing rules and guidelines, but creating a parallel set. And we're not going to do that by next week. Just want to Okay.
You
All
mean
right.
for just the moral character aspect?
Yeah.
Oh, yeah. I don't know. I mean, if we are simply replicating the identical process, but I don't think we would be, because they wouldn't be going to the committee of bar examiners
Right.
at the interim stage of, so we would probably have to have another chapter within that division of that Title IV rules. So, for that.
Right.
Or I don't know. I mean, we'll have to figure out from a rule perspective if we just have a new title just for paraprofessionals that replicate a number of rules.
So are we saying that it would go, they make an application, their appeal then would go to what body, Greg?
Well, for lawyers, I believe it's in, I'm going to test my knowledge here. I believe for lawyers, there's a staff review, and then if they receive an adverse, well, there's an informal conference if they're if they're leaning towards an adverse determination.
Mhm.
And there's some opportunity to be heard and present some evidence at that. And then once they've made an adverse determination, the applicant can appeal to the committee of bar examiners. And if they receive an adverse determination at that point, that is when 9.13 rule 9.13 kicks in, and they have an opportunity to petition the court, and the court has discretion whether or not they want to take that case or simply affirm the committee of bar examiners determination.
And doesn't it go to state bar court? I think.
Oh, I'm sorry, you're right, state bar court. It goes to the review department, right? That's right.
So.
Yeah,
So would there be, are we envisioning that there's going to be another committee body that's going to hear the first application?
It's not the first application. In the attorney side, the informal conference is also done by staff now.
Yeah.
But if they're after that phase, I think the parallel to the committee of bar examiners in our world would be the paraprofessional board. And
Okay.
it would be perhaps a committee of that board.
Okay.
And that board, we're putting a lot on that board right now, I think, from all these different subcommittees, because that board's also going to have played a significant role potentially in the disciplinary process.
Yes.
And that's different than than for attorneys, because we have a dedicated state bar court for those disciplinary proceedings.
So that sounds like those details will be ironed out further down the road.
Yeah.
Well, we started the discussion about the board at the last meeting, and you'll definitely be having many opportunities to weigh in about the board. It's got a lot of responsibility, and right now recommended for 13 members, which, depending on how much work there is, may be too small.
All right.
Okay.
Okay.
Thanks,
Great.
everyone. Have a
Thank
good
you.
night.
And
Everybody good. Stay safe.
Okay.
all right.
Yeah, and Happy New Year, everybody.
All right.
Bye.
Thanks.